and this is about to get good. I wanted to announce to you all as well that see, I want to say something to Elaine Jones, but I'm scared of her. A little bit. Elaine Jones? Hey, I want everybody to see Elaine Jones is here. Yes. Yes. And now we are starting. I want everyone to be aware that we also have with us an original copy of the 14th Amendment. And it is here on this easel, and I want to thank Lawrence Benenson. I think he's here. He was here for a private collector for sharing this with us. And so when you have a chance, at the close of the next panel, come on by and see the real thing. It's real. We didn't make it up. The next panel and the next discussion is going to be really important. If the first blew your socks off, then this one will as well. This panel is a different kind of presentation. It's a way to think about what strategy conversations might look like within the center. And we are focused in particular on some of the forgotten sections of the 14th Amendment, which I spoke with you all about earlier, Section 2 and Section 3. And then the way in which we could return to Section 1 of the 14th Amendment and imagine a kind of invigorated Section 1 and making it available for the protection and invigoration of rights that we don't currently associate with the 14th Amendment, the right to literacy and reproductive rights. We're going to begin first, however, with Section 2 of the 14th Amendment, which is on the screen. And as I shared with you all, Section 2 of the 14th Amendment has never been used, at least to my knowledge, and I will tell you, I feel like I'm still learning all the time, so maybe I'm going to find something. But it has never been utilized. This section was created by the drafters of the 14th Amendment because they believed that Southern states would resist allowing Black people to vote. And so they created a punishment structure by which those states that denied the vote to men over the age of 21, because remember at this time women couldn't vote and 18-year-olds could not vote, the voting age was 21, that those states that engaged in voter suppression would have their representation reduced by the amount commensurate with the number of people that whose vote they suppressed. Now, we have a Voting Rights Act. That's the route that we went in the 1960s, the Voting Rights Act of 1965. And you know I have been a voting rights litigator since 1988, and so I believe in it. And we have had efforts to try and amend it to restore its strength since the Shelby County versus Holder decision in 2013. But this is the way the framers envisioned it would work. This is how the framers thought, the framers of the 14th Amendment thought that we might compel all states to allow all eligible voters to vote. So the first conversation is going to be with some fantastic and illustrious folks who we're going to talk about Section 2 and how, if we wanted to activate it, would it be activated? What would it look like? Who would have to move? What would Congress have to do? How could we get it going? And we'll hopefully return to a conversation about whether this is even a good idea. I know Deuel Ross has strong feelings about whether this is even something that should be done. And then Section 3 we're going to talk about, which is the section that says insurrectionists can't hold office. We know that the Supreme Court decided Trump versus Anderson, and we're going to ask for a briefing and an update from Donald Sherman, who is the, I want to say Executive Vice President, is that right? Executive Director. That. Of CREW, which is Citizens for Responsibility and Ethics in Washington, and they do such great work. They're involved in a number of lawsuits, and they were the lawyers who were involved in that lawsuit in Trump versus Anderson, challenging the placement of the former president and now president on the ballot because of Section 3. And then we'll go to the conversation about literacy and about reproductive rights. So on this panel, we have with us my dear friend, and also just a shining light as a constitutional scholar in the United States Congress, a man who always speaks truth to power, a man who is self-sacrificing, and I'm sure is very embarrassed that I'm saying these things, but who always makes us so proud. We're so proud when he speaks, we're proud when he's in front of the microphone. Somehow he manages to keep a twinkle in his eye and a sense of humor despite all of the pressures that he is facing, and we just love him. And that is the Honorable Jamie Raskin, who is with us. Joining Jamie Raskin for the conversation about Section 2 is someone who I have the utmost respect and admiration for, Deuel Ross, who's the Deputy Director of Litigation at the NAACP Legal Defense Fund. I'm proud to say I hired him at LDF many years ago, and he is an absolute brilliant litigator. He won his case in the Supreme Court last year, Milligan versus Alabama. Okay, sometimes it's the Secretary of State whose name I didn't keep up with, but okay, Milligan versus Alabama, which Allen, see, that's what I'm saying. Which was a racial redistricting case that ensured that we got an additional seat, majority black seat House seat in Alabama. He is a brilliant litigator, not only of voting rights, but also in the education space. And he is literally Mr. Alabama. To this day, he does not work for me, but I will call him and I will say, tell me about when they started requiring voter ID for whatever, and he will give me the chapter and verse. He knows everything about Alabama voting, and indeed voting around the country. He has an encyclopedic memory for this stuff, but he is just a brilliant litigator, and he's going to be in conversation with Jamie Raskin. Then when we move to Section 3, we're going to hear from Donald Sherman, which I already mentioned, and I'm very happy for Representative Raskin and Deuel Ross to join that part of the conversation as well. Then we'll be joined by Leah Epperson, who is a professor at American University College of Law and the inaugural Microsoft Technology and Racial Equity Fellow at Howard this year. So she's in the office next to mine. And Leah is also a former LDF attorney, so you see how I'm, yeah. And she is an education scholar and was an education litigator, and really just has a mastery and brilliance in this space. And so she's going to talk with us about potentially imagining a right to literacy in the 14th Amendment. And then we will finally be joined by Serena Mayeri, who's a professor of constitutional law at University of Pennsylvania, Carey Law School. She is one of the authors of the brilliant amicus brief that was filed in the Supreme Court in the Dobbs case, in which she and her co-scholars envisioned an equal protection argument, particularly focused on black women for reproductive rights. And she's going to talk with us a little bit about that today. So I am thrilled about this panel. I'm excited about this conversation. Y'all come on up and take your seats and strap in, folks. Get ready. Terrific. So I want to begin with Representative Raskin and Deuel Ross and talk with you a little bit about Section 2 of the 14th Amendment, which imagines this reduction in representation, which, I find intriguing. What I recall is that when we brought suit and successfully won at the trial court, and that's another question to ask, is like, how far might this have to go? Around the voter ID law that was imposed by the state of Texas beginning in 2013 after the Shelby County case. That voter ID law was the most restrictive voter ID law in the nation. Many of you may recall it. It removed the ability to use your state employee ID for voting. You could no longer use your state university ID, which our clients, students at Prairie View A&M, had used previously. You could not use your tribal ID to vote. You could, of course, use your concealed gun carry permit to vote. So we challenged this law, and we won at trial. And at trial, as I recall, and Deuel's going to correct me if I'm wrong, that the trial judge estimated that somewhere around 500,000 people were disenfranchised by that. Yes?
Registered voters.
Registered voters.
Over 1 million eligible voters. Yeah.
So the trial court found that over 1 million eligible voters were potentially disenfranchised by this law, and that 500,000 registered voters. So that's a number, right? Now, I won't bore you with the details of where that suit went and up and, and we did get some of the law changed, and so we were successful. But let's just start with the 500,000, with the 500,000, right? In a state like Texas. Would that be enough? Would you take a judicial decision, a judicial verdict, identifying the number of people who were disenfranchised by a practice And could you then is that what it would take, or could I just come in with some expert testimony? Like, how would we even know how many people were disenfranchised? Just to start with the formula, right? Because it's like how many you disenfranchise reduces your representation. So we have to start with the first decision point. How do we know? What would fly?
Well, let me preface it by thanking you, Sherman, for putting on this excellent, timely, and urgent conference, and congratulations on the creation of the new center. And when I consider Sherman, I guess I would say with Tim Snyder, the two of them are two most important public intellectuals, and he's going to Canada. So that leaves you, Sherman. I hope you're not planning to move anywhere. But when I first learned from Sherman about the creation of the new center, I said to her immediately, fantastic, your new center, I'm assuming you're not just going to focus on Section 1. We need to know how to breathe life back into Section 2 and Section 3. And I can't wait for you to create your new center. Now she's created a new center, and she's asking me. And I'm waiting for the center to give me all the answers here. But look, if you don't mind, can I just provide a little historical, textual context to it, okay? Because I don't think you can really understand Section 2 of the 14th Amendment without looking at the 3/5 compromise, right? And then the history of the 3/5 compromise. Now, just to refresh everybody's memory, when the Constitution was written, the question in the formulation of the census and then the apportionment and the representation provisions was, well, what do you do with the large population of enslaved people who are not allowed to vote? And some people were confused about this. The northern states were saying they should not count at all for the purposes of reapportionment because you're not allowing enslaved people to vote, much less to run for office. And so why should they count for the purposes of giving representation to the southern states, to the slave states? The slave states said that for these purposes, and these purposes only, no, they should count as 100% people. We should count them 5/5, because that's going to enlarge the congressional delegations from the southern states. And they fought back and forth about it, and they arrived at the infamous 3/5 compromise, which was a ratio that actually was built into the Articles of Confederation for other purposes. But they said, well, let's use that number. And sometimes people are confused about this because they think that it was the slave states, the white supremacists from the South, who were saying, let's count them only 3/5. They would have been very happy to completely count those people, but of course not give them the right to vote and to participate. So anyway, the 3/5 compromise then inflated the southern congressional delegations by adding 60% of the enslaved population. And that's why in the 1800 census and reapportionment, there were an additional dozen members elected from the slave states. That translates also into the Electoral College, too, because, as you know, the presidential electors are the number of representatives plus the U.S. senators. This is what the Northerners called the slave power, the power that the white supremacists and the slave masters got out of counting 60% of the enslaved population for purposes of reapportionment. Well, after the Civil War and after Reconstruction, and the 15th, giving everybody the right to vote, then the African Americans were going to be counted 100%, which was great, if they could vote. Now, if they couldn't vote, at that point, that further inflates the power of the slave master, or of the white supremacist class in the South. So that was the importance of Section 2 of the 14th Amendment, saying, yeah, we'll count everybody now. Everybody's going to be counted, but they've got to be given the right to vote. If not, we're going to subtract from that overall basis the people who are disenfranchised. So your question is then essential. Well, what does it mean for people to be disenfranchised so we can determine what we're subtracting, right? Now, and I don't don't know that I've got an all-purpose answer to your question, but
And
I'll tell
I
you-
don't mean today in this particular United States Congress because,
Right.
yeah, or else we have to just close up the panel. So let's dream a dream.
But you saw that the incumbent president issued an executive order this week. I think it was this week on voting, right? And one of the things that they want to do in their alleged purge of non-citizens, illegal non-citizens from voting, is to say everybody now must adduce at the point of voting identification, current identification that matches their birth certificate. Now that's a nightmare for married women, 80% of whom change their last name.
Stop doing that.
Yeah. Well, that's a different conference, okay? That's the Equal Rights Amendment conference. But so 4/5 of women, or majority of women, are going to show up, and their driver's license is not going to match their birth certificate. So now you got to produce your marriage certificate, your ketubah, or whatever. You got to show how your name changed, right? And so that's going to be disenfranchising a lot of people, which gets into another problem, which I think Section 2 of the 14th Amendment is the only place in the Constitution which inserted the word male, which is why some of the feminists were opposing it, right, at the time, right?
Most.
Yeah. So there's that additional wrinkle that we've got now. But let's say it was...
But that's struck down by the 19th Amendment, the
Right.
word male.
Is there a holding to that effect?
Well,
Yeah.
it's never been used, so we can't get a holding. But if you
Yeah.
look at iterations of the Constitution that are now
Yeah.
produced, that
Yeah.
word is struck.
I love that. Okay, I hadn't even thought of that. So you read the word male there through the prism of the 19th Amendment.
Just
and
as the
male
3/5 clause you don't read anymore either, or the
Yeah.
importation of persons, or the other things in the first
futures
part of the...
Yeah. All right, so male means male and female, but only male and female, just two genders now under
And,
executive
and you
branch.
also strike 21 years of age because of the amendment that allows 18-year-olds to vote. So
The
when you see
26th Amendment,
yeah,
yeah.
so when you see new iterations
All
of
right.
the Constitution, they're struck.
Well, you solved that problem already. You solved that problem already. All right, that's great. So then the question is, well, we're going to get immediately into a, does it have to be an explicit intent-based standard, or is it an effects-based standard? Like, okay, all those women who are disenfranchised, well, they say, well, that wasn't the purpose of it. The purpose of it was to, just to exclude the undocumented people. But I think that we're going to have to develop a doctrinal jurisprudence around precisely mechanisms for determining who's been disenfranchised and how. And of course, the radical Republicans would have said it's effective disenfranchisement, right? Because it includes grandfather clauses and literacy tests and poll taxes, right? And so it doesn't necessarily have to be an explicit exclusion.
But the question I'm asking is, if you have a judicial finding, right, in a case, that a particular practice by a state, voting practice by a state, has disenfranchised X number of people, is that enough? You said we need a framework, and I'm saying, how much more do you need than a judicial judgment?
I mean, since we're in a utopian frame of
Yeah,
mind
I mean,
here,
we've got
okay,
to.
I mean, I'm assuming that we've got congressional majorities that are interested in using
Yeah.
Section 5 of the 14th Amendment
Yeah.
to give muscle, for the first time in American history, to Section 2 of the 14th Amendment. I mean, I think that certainly this Supreme Court, if we are counterfactually assuming them to be part of our utopian experiment.
I don't think we can go quite that far, but okay.
Yeah, but that they would do to Section 2 what they just did to Section 3.
So you need legislation.
You
or
need
something.
legislation to do it. And so say we've got a new radical Republican-style Reconstruction majority in Congress, we would say you can go to court, you can prove that there have been voter suppression, discrimination, and disenfranchisement measures undertaken which have lowered the ratio for the purposes of Section 2. A judicial finding is controlling. And then, that is for Congress at that point to act upon.
Deuel, do you agree with that? Would it take legislation?
I think that there's already been litigation even recently, including from Jack Greenberg back in the 60s, trying to enforce the Section 2 of the 14th Amendment, and unfortunately, it's been unsuccessful. I think not on those basis, on the basis of standing, but I think it would take an act of Congress to clarify what does it mean, how is it going to be enforced, all of those things.
Well, let's talk about standing for a second, because even if you had this congressional statute that explained the process, who would activate it? In other words, would it take Deuel, representing folks in Texas or in Alabama, then petitioning, like what would happen, or is it self-executing?
In general, the way it works is the Secretary of Commerce, after getting the census report, writes a letter to the Speaker of the House of Representatives saying, here are the numbers in the state.
Okay.
And so this would become part of that process that the Secretary of Commerce would be instructed to
By who?
deduct. By the court. The court would issue the ruling. It'd be declaratory and
Wait, hold on. So you're saying the court that finds that 500,000 people have been disenfranchised would then transmit that to the Secretary of Commerce?
Well, it would be a declaratory ruling, presumably declaratory injunctive ruling that would, I don't know. They don't have to mail it to them, but I think it could be.
We have computers now, but I'm saying,
it would be published, and
who would make it happen? Like, in other words, would it be the residents of the state who would be saying reduce our representation, or would it be someone?
Well, that comes down to how we write the statute, but I would say that anybody could petition, right, or anybody aggrieved in the state by virtue of a disenfranchising practice has standing to go to court to get the court to declare that 500,000 people have been effectively disenfranchised within the meaning of Section 2 of the 14th Amendment. The court goes through the whole fact-finding process, declares it, and at that point, maybe that's built into the statute that either the Secretary of Commerce shall subtract those numbers for the purposes of alerting the House of Representatives how to apportion in that state.
Deuel, does that work, and can Congress by statute create the standing, or isn't standing a jurisdictional issue that courts can? Okay.
It is, but a trifle is enough for standing, in theory, until the Supreme Court changes it.
Okay.
I think,
Yeah, please, go.
maybe to step back on this, I think one thing when Sherman, who I just have to very briefly acknowledge several people in the room, first my professor, Mayuri, my judge, Judge Gregory, who was the first person to ever hire me. I won't point him out, but he's somewhere. Fine, where's Waldo? And then Professor Eiffel, all of whom have been really instrumental in my life, and I very much appreciate you all having me on this panel. But I do want to ask this question, which is just, is this something that we want, necessarily? And that's because, as we were just discussing, the progressive option at the time the Constitution was adopted would be for Black people to be counted wholly and fully and able to vote and be fully a part of this nation. That was not what actually happened, as the Congressman already said. But then the progressive fallback option, right, was not to count Black people at all, right? That was a different time, a different place. Remember when the 14th Amendment was passed, it was before the 15th Amendment. It was before they were even sure they wanted to give Black people the right to vote. And so it was also premised on this idea that states could continue to fully disenfranchise Black people, and then the punishment would be, well, if you're going to disenfranchise in Alabama and most of the South, right, we're talking half the population or close to it. If you're going to disenfranchise half the population, you don't get 8 or 10 congressmen, you only get 5. In today's world, when you're talking about, Texas, wherever, Alabama, my favorite state, disenfranchising a portion of the Black population, and then you tell that state, Alabama, that has 7 congressmen, you're going to lose 1 member of Congress. Which member of Congress is Alabama going to choose to cut, right? They're going to choose to cut the Black member.
Well, who said it was Alabama's choice?
That's fair. That's fair. I think, but I wanted to just point that out, not as and then I'll start there, but I'll end in a more positive place, which is that when I first read Section 2 of the 14th Amendment sometime in law school, I was amazed that it existed, because I read it And I was like, this is an affirmative right to vote in the Constitution that doesn't exist anywhere else. I think the unfortunate reality is that every court that's ever read it, and there are a few judges in this room, has always read the portions that we see, right, that only people over the age of 21 have the right to vote. Only men have the right to vote. Richardson versus Ramirez, the famous felony disenfranchisement Supreme Court case, read it and said, okay, you can disenfranchise people who are convicted of a rebellion or other crime, which was interpreted much more broadly than the Reconstruction Congress interpreted it. And so I say that to say I think that there's a lot of hope in this section, because if you read it the way I first did when I was a law student, as this is the right to vote, this is the closest we have in the Constitution to a right to vote. And I think that is the way that we have to, if we're thinking about a world in which we want Congress to actually enforce this provision, I think we have to read Section 2 of the 14th Amendment itself more broadly as this affirmative opportunity for us to see that the Constitution actually does not permit these broad levels of disenfranchisement for people. And reading it in that light, I think that you can come up with a strategy, a criteria in which the state, I don't know if it's the state, it seems like it would have to be some kind of the executive itself, which, You
mean the president?
I think so, right? Because you have the, okay, well.
Why are you bringing?
I'm not saying that the president should.
Apportionment and representation.
I'm not saying he should. But what I'm saying is that what is I'm trying to think through the mechanism.
And in this utopian world, it's she, not he.
I know, you're right. Yeah. I'm thinking about the utopian world, right? And what I'm thinking about is who is going to make the decisions, right? And I think that's probably a hard question. Just in terms of the Commerce Department does the census. The Commerce Department then sends out how many people we're going to count, tells all the states how many people we're going to count. And at least in the way it currently exists, right, the Commerce Department is under the executive. I'm not saying that that's the way that we want it to exist, but I'm saying that that is the reality of how it exists today. And I think we have to come up with a system in which, whether it's Congress, it can't be the states, because the states are going to choose people we don't want to lose their members of Congress, in which maybe it's the courts.
I don't know that that's necessarily true. First of all, I love the fact that you're both really loving the Commerce Department on this. I think this is great.
No love for the Commerce
This is great. But no, I guess what I'm thinking, and it actually raises another question. One of the reasons I get a little nervous about Section 2 is because I think, as we know, most black people live in the South. 52% of black people live in the South. Most black people live in red states. And I think, why would we be reducing the representation of black people, right, writ large, right? Like if you're reducing Alabama's representation, just writ large, forget about which districts, you are reducing the influence and the power of those states in the legislature. And so that feels a little bit queasy for me. My presumption was that you could not pick the districts from which you are disenfranchising people, right, in terms of the Congress people who would be reduced. But what do you think about that, about this kind of overall sense of, so we reduce the influence of the very states, which are the states where most black people live? Is that?
Well, you go back to pre-Civil War. That was the argument that the slave masters were making. Oh, well, we're going to represent everybody. Everybody's going to be.
Okay, but they were lying.
Right.
You know what I mean?
Yeah.
Alabama made that argument in February of this year, too. So.
But that's essentially what I mean. If they are really undertaking practices that disenfranchise large numbers of people, are those people better served by having a larger, all-white delegation serving particular interests, or a smaller one? And remember, because I think it's a powerful point about who the legislature will try to draw out. Of course, if you've got a situation like Alabama, where we've just added a second majority African American or influence seat, you might not be able to completely exclude people, at least without endangering other seats. But the other thing is, don't forget about the Electoral College, because you're reducing the Electoral College vote for that pro-traditional white supremacist coalition at the same time, even if they're all willing to give up 1 or 2 seats. You're talking about 5, 6, 7, 8 seats. That makes a difference.
And you've raised one other thing, which is just by talking about the new executive order, that voter suppression is not an equal opportunity game, but it does affect more than Black people, right? And it does affect more than Latino people. So as we see these additional features
Yeah.
that may become popular, and there's nothing in Section 2, even though they meant Black men, there's nothing in Section 2 that says Black. And
That's
so,
right.
right? So
That's right.
at the
It's
end of the
written
day,
neutrally there.
Yeah.
And I take Deuel's point that you wouldn't always want to do this. Obviously, it would be a strategic decision. And there is that sense in which Section 2 of the 14th Amendment is kind of an imperfect, rough draft of the 15th Amendment, and it's better just to have muscular enforcement of the 15th Amendment. But it's not bad to have, a safety valve option in places.
and the 15th Amendment has no punishment. I mean, it says Congress shall enforce, but like for the states, it's why they can take their chances, because what's going to happen to them if they deny them? Then we have to do years and years of litigation, and maybe we get the relief we want. And I mean, the key to Section 2 is that it was meant to punish. It was meant to give an incentive to states not to engage in voter suppression. So I think it stands apart from the 14th Amendment, and in some ways, 15th Amendment, and in some ways is stronger than the 15th Amendment because, as I was suggesting earlier in the opening, this Congress understood the stubbornness of white supremacy. They understood that these states were not going to allow Black people to vote, and yes, they did not want to create an affirmative right to vote for Black people themselves, which would obviously have solved the problem, but what they wanted to do was to come up with an incentive, and the incentive was the punishment.
That's right.
So I think Section 2 is important. Donald, you want to weigh in on this very quickly before we go to Section 3? You like this? You've got the statute written up, drafted up?
I do not. I think we've all acknowledged that we are not quite yet in that utopia that
Well, we have to have it ready. That's the
We do.
point. This is
we do. And I agree with Deuel that thinking about what this looks like in the real world has to be paramount in thinking through an approach. And frankly, whether Congress can be trusted to execute, even if we get a draft of legislation that we think will be effective and avoid potential unintended consequences. But certainly, we are at a moment, as you said earlier, where we should be thinking about how do we reimagine our democracy. And I think looking at the second founding of our democracy is critical to that, including Section 2.
Yeah, I mean, I think we spent a lot of time. I mean, I spent my last 2 years at LDF, trying to push for the Voting Rights Restoration Act and various acts that were going to amend the Voting Rights Act, which has really kind of been where we've been focused. And that's not a problem, although frankly, I think, and we can talk about this another time in the next session that we have next semester, I really want to talk about that and whether we've not moved past that. I mean, we have states that are basically taking power away from elected officials if it's an elected official they don't like. So I'm not sure that any iteration I've seen of the Voting Rights Restoration Act deals with what I would call those third generation problems, building on what Lonnie Grenier wrote many, many years ago. They're now doing, they're now removing the power. So, the governor gets elected and it's somebody we don't like, it's a Democrat or whatever, then we take away that governor's power to appoint people to these various boards and so on and so forth. So, so since we're, it's not as though we're not trying to pass legislation in the voting space. We are. And I'm asking whether by putting all our eggs in one basket on what we know is a imperfect, solution, might we want to, have in the bottom drawer something else?
I think it's really important for us to be thinking about this and asking the question, right? I don't know what the answer is, but I do think that the answer is to talk about this. And I think for too long, the civil rights community, activists, lawyers have thought within a narrow box of these, we enforce the 14th Amendment, Section 1 or Section 5 through whatever Congress passes, or we enforce the 15th Amendment, or sometimes, very rarely, the 13th Amendment, and that's it, right? But I think what other folks often do is do what we're doing now, right? Imagine a robust Second Amendment. Imagine a robust, different First Amendment than we currently have. And I think that whether it's Section 2 or it's reinterpreting Section 1 or looking back at the 15th Amendment or any other amendment and saying, like, what is missing here? What is the thing? And you can go back to even some of the original documents. I have it written down here. One of the early drafts of the 15th Amendment prohibited property requirements, literacy requirements, nativity requirements. Why? Because they knew exactly what was going to happen. They predicted what was going to happen over the next 100 years. And so I think it's important to look back at what was done in the past, but also to imagine a different kind of world. And I don't know that it's Section 2 or Section 3 or Section 4, but it is important to ask those questions now.
Yeah, I absolutely agree. We're not in a position where we can, allow kind of some of these provisions to lie follow. I mean, we have to vigorously shape them and figure out what we can get out of them and try to figure out new things, particularly in this very challenging time. And as the conceit of this conference is get out ahead to the next moment, to try to begin to imagine the next moment and not put 100% of our energy into the current moment that we face, so that we're ready for any change of power to be able to move with certainty and innovation and power. I'm going to now go to Section 3 of the 14th Amendment. It's now on your screen, and Section 3 is the section that indicates that those who participate in insurrection cannot serve in either federal or state office, and this one has been tried, and it was tried last year in Trump versus Anderson, in which the Supreme Court made a big deal about the fact that it's never been tried before, at that level, and of course, I thought that was a badge of honor, that we don't regularly have insurrections, but apparently that was problematic, that we didn't have precedent to draw on from this insurrection provision of the 14th Amendment. And Donald Sherman's team at Crew was very involved in the litigation, and we got a decision from the Supreme Court that in essence stated that Congress would have to make a move, that it was not a self-executing provision of the 14th Amendment. And so I wanted Donald to bring us up to date on how they interpret what that meant and to go the next step. What do you think do we then now just consign Section 3 to the dustbin of history? The answer is no to that. Yeah. But if we're not, and it still lives, could we, if we took the Supreme Court at its word, what would it look like? What would the statute have to say? How would we move forward to keep Section 3 alive?
So first, let me join my colleagues here and express appreciation for you, Professor Eiffel. I'm a kid from Queens whose first legal internship was at LDF under the leadership of Ms. Jones, and so it's a particularly special treat for me to be here. And I think this was alluded to earlier, but people think that a lot of people think that litigation just happens. You just walk into a courtroom and judges do a thing and you make some arguments. But so many of the people sitting up here were integral to us being able to bring novel litigation to enforce Section 3 of the 14th Amendment, including Congressman Raskin and his leadership, you, Professor Eiffel, being a thought partner before we got to the Supreme Court, when a lot of people decided that they wanted to help.
Yes.
LDF for a really powerful brief that was neutral technically, but we considered very valuable and helpful. And just one other point of clarification. While this issue was novel, Crew not only brought Trump v. Anderson, the case that went to the Supreme Court after taking Donald Trump off the ballot in Colorado for violating Section 3 of the 14th Amendment, but we also brought the case in 2022, the first and I guess now only case in the last 155 years to remove someone from office using Section 3 of the 14th Amendment against an adjudicated insurrectionist named Coy Griffin in New Mexico. And that context is valuable because I think it informs part of what is left after the Supreme Court's ahistorical, atextual, and imagined analysis in the decision in Trump v. Anderson, which, as you noted, essentially said, in order for Section 3 to be enforced against a presidential candidate, Congress has to, through legislation, create a process for doing so. None of that is in the text, but it also the decision also helpfully noted that states can enforce Section 3 against state officials. And so that little aside allowed our state case against Mr. Griffin to remain in force. And so as a starting point, Section 3 can be enforced against state officials through state ballot state ballot access statutes, with, of course, the caveat it depends on what state law allows. But in that New Mexico case, New Mexico and lots of other states have what's called a quo warranto provision, which allows voters in many instances to challenge the seating and remove a government official who is ineligible to hold that office. And so we went into a trial court in Santa Fe, New Mexico, and proved that Mr. Griffin, who traveled the country from New Mexico to DC, encouraging people to come and fight for Trump, encouraged people, told people that we were at war, that it was a civil war, and then rallied people outside the Capitol as they were crushing police officers and storming the Capitol, that not only, the court found that not only was January 6th an insurrection against the Constitution, but that Mr. Griffin, through that conduct, engaged in insurrection. And so that case and the Supreme Court's treatment of it in Anderson provides a roadmap at the state level. At the federal level, we are left with a couple of different avenues. I think there's differing scholarship about whether Congress could have declined to certify President Trump's election on January 6th. But the Republican majorities in the Congress obviously made that a nullity. I think it also begs...
You mean of this year?
Yes.
Of this year.
But it also begs the question that Deuel and others have raised, which is that something that should be done? And I think for us, it's one of the reasons why we brought our case as early as possible, because we wanted to ensure that if this provision was going to be enforced, the practical reality was that it was enforced before most Americans started voting, even in the primary process. And I would be remiss if I didn't say that ballot access is an imperfect tool to enforce the Constitution. It is the tool that was left to us because the Senate abdicated its responsibility in the immediate aftermath of January 6th. It was left to our clients and us because, unfortunately, the Department of Justice didn't move as quickly as I think it could and should have to enforce whether it's the insurrection statute or others against Donald Trump, specifically for his conduct related to January 6th. As it stands right now, our case in New Mexico is the only trial in a court anywhere in America that has adjudicated the questions of Donald Trump's conduct with respect to January 6th. And it may be the only one that ever does. And so going forward, I think I am hopeful for a time and place where Congress can set about the task of drafting legislation that can move through Congress to meet the Supreme Court's mandate and give force to Section 3. I think, honestly, I don't think that it was necessary. I think that the court elegantly punted to Congress, knowing that Congress wouldn't do anything. But I also believe in the rule of law, and I believe that they have the final word. And so here we are. And so
What would the legislation look like?
So,
And then we'll let Representative Raskin weigh in.
I mean, I think you would have to deal with some, very practical challenges about, who can sue, where, what court, would it be limited to, would you be able to sue in any district court across the country? Would it be limited to the DDC, the District of Columbia, and the DC Circuit? And it might include a definition of insurrection, which was one of the things that we had to wrestle with, and we had to get experts to define. One of the challenges we had to do was how do you locate the definition of insurrection without encroaching on the First Amendment, and so we had amicus briefs and scholars testify on those issues. And so it is not an easy task, but I think covering those sort of big buckets is the first step necessary for Congress to tackle.
I don't want us to understate the achievements of Donald Sherman and crew in what they did in Trump versus Anderson, and then the victory in the Griffin case. It's a provision of the Constitution that has been, as Sherilyn was saying, underutilized, and for good reasons. You don't have presidents who incite violent insurrection against their own government come around more than, once every couple centuries. So there wasn't a well-developed body of jurisprudence on it. But I really think that Crew's litigation was extraordinary, and the fact-finding in Colorado was amazing, and what they did in the Griffin case was also great. And I'll talk about the statute in 1 second, but I want to underscore the importance of this matter, because a lot of people, including the Supreme Court, treated Section 3 of the 14th Amendment as some kind of minor or eccentric or atavistic relic of just the Civil War period. Insurrection is a critical element of the entire Constitution. There are half a dozen mentions, either explicitly or allusively, to insurrection in the original Constitution, right? From the very beginning. So Article 1, Section 8, Clause 15 says, Congress shall have the power to call forth the militias of the states in order to repel foreign invasions and suppress insurrections. Right? They wrote the Constitution in the shadow of Shays' Rebellion, and they understood what an insurrection was, and the founders were completely opposed to it. They said, we're creating a social contract and a civil society where you don't mobilize violence in order to get your way. The treason clause is the only place in the Constitution where a crime is defined, and treason consists only in levying arms against the United States or adhering to the enemies thereof. The Republican Guarantee Clause says Congress shall guarantee to the people of the states a Republican form of government and to assist them in suppressing domestic violence, right? And there's several other parts that leading up to Section 3 of the 14th Amendment, which makes this powerful point perfectly clear. Anybody who's sworn an oath to uphold and defend the Constitution against enemies, foreign and domestic, who violates the oath by engaging in insurrection or rebellion against the United States, or rendering aid and comfort to the enemies thereof, shall never be allowed to hold state or federal office again. And it was staring the courts and it was staring America in the face after what took place on January 6th. So I did introduce legislation with Debbie Wasserman Schultz in the 118th Congress to allow for a cause of action by the Department of Justice in the District of Columbia courts to seek declaratory and injunctive action stating that somebody was an insurrectionist and therefore was bound by Section 3 of the 14th Amendment. We never got a vote on it. It never emerged there. The other part of the provision is that if the DOJ doesn't bring it, or simultaneously any citizen can petition for it, the DOJ would have the authority to take over the lawsuit if they wanted to, and if not, then the suit would proceed based on the standing of any citizen who alleges that they were, that they are aware that there's an insurrectionist who's potentially.
How did your colleagues respond to this legislation? Did they think it was a matter of urgency or something important?
Well, of course, my Republican colleagues evinced little interest in it. And I would say it was generally positive, but a mixed reaction on the Democratic side. And there, when you live through an insurrection, there's always that undertow of, well, let's let bygones be bygones and let's try to forget about the whole thing.
Okay, so first of all, the words, when you live through an insurrection,
Yeah.
as one does.
But I would say most people
Yeah.
felt and continue to feel that we cannot allow the whole thing to be swept under the rug. I mean, the political scientists tell us that the surest sign of a successful coup coming is a failed coup where they get to diagram the weaknesses in the regime and then exploit them the next time around. So we're still in the middle of this process, of course, and I think it's important to talk about Section 3 of the 14th Amendment and how to make it real. I mean, if you go to the second impeachment trial, where we got the most sweeping bipartisan vote in a Senate presidential impeachment trial in history, 57-43, but of course, Donald Trump in his inimitable way beat the constitutional spread because it's a 2/3 requirement, and so we were 10 Republican senators short of doing it. But if you look at that, it's fascinating because Mitch McConnell made this speech at the end where he said, well, Donald Trump is actually factually, ethically responsible for everything that happened, and it was clear that the House managers had made an overwhelming case of that. He said, but we did not have jurisdiction to try a former president, which was a proposition refuted, we felt, by more than 2 centuries of practice in impeachments, including of impeached judges, and that issue was always raised because everybody would just resign before being impeached if you could escape that way. But the Senate had always held, no, you're subject to it. But also, that had been explicitly raised in a motion on the first day of the trial and rejected in a 56-44 vote, which I think makes Donald Trump's second impeachment trial the greatest case of jury nullification in American history, because the Senate understood that legally this had been rejected for the court of the Senate sitting, and they went back to that legal claim in deciding the facts, or disregarding the facts, as McConnell very clearly did when he said that the evidence showed that he was actually and ethically responsible. Now, here's the thing. They said that Donald Trump was not subject to the jurisdiction of the Senate because he was not president. He is president now.
Silence is so good. Silence is good.
So,
Donald, can you just wrap up on this part, and then we're going to go forward? Just give us a little bit more on this.
Sure. And so, one thing that I will say is that I think the declaratory judgment piece of this is so key because, again, we live in the real world. It's just much harder, for better or for worse, to enforce this kind of provision once you have had an election. And so being able to get into court early is critical. But what I would say to Congressman Raskin's charge and the import of the center is that one thing that was particularly galling for me and that the Supreme Court seemed to lose sight of is what it cost to get the 13th, 14th, and 15th Amendment, right? This amendment was paid for in the blood of our forebears. And all of a sudden, this case is in front of the Supreme Court, and somehow the moment is too big for them. And as a result, they treated the 14th Amendment as too small for what it is and what it cost us to gain. And so I think that's incredibly important to remember. And then the last thing I will say is to Congressman Raskin's point, if the Supreme Court can do an elegant dodge around the 14th Amendment, I would not. I think other amendments are next. I think the 22nd Amendment is next. And we should be mindful of that. And that, Sherilyn, you were right in your amicus brief when you said that Section 3 was there to ensure the enforcement of Section 1. And of course, we know that one of the first things that Trump did after dodging Section 3 was come after Section 1. And so this is going to continue to be a live issue, and it's incumbent upon us that if we want the 14th Amendment, all sections of it, but particularly Section 1, to have power, we cannot lose sight of Section 3.
Yeah.
Yep. Okay, wow. So we're going to move to Leah Epperson, and we're going to talk about literacy. Education is the very foundation of citizenship. Those are not my words. Those are the words of Chief Justice Earl Warren in Brown versus Board of Education. We think often about the decision as one that struck down segregated education, legal segregated education in our country. But it's worth spending time looking at the things the court says about education in that case and the relationship between education and citizenship. And so I wanted Leah Epperson to come and talk with us a little bit about the right to literacy. Many of us live in states or other jurisdictions where literacy rates, particularly among the Black population of children, are shamefully low. Where in schools that are not adequately resourced to ensure the literacy of students. And if it is the very foundation of citizenship, then it is an attack on the citizenship of those children and their ability to be full citizens in our country. So I wondered if you would talk about that. We don't have very much time left. I think we have 5 minutes and 5 minutes for you and Serena, and then I'm going to make sure we have a little bit of extra time. I'm going to just bogart it and take it. Okay, but please, go ahead.
Sure. Well, thank you so much for having me on the panel. I am so fortified and excited by today and everything we've heard to be in community and also to just watch what the great Sherilyn Ifill is building here, which we need for the blueprint for the new nation. So I'm so grateful to be a part of it. And also next to our beloved Congressman, who also hired me and chaired my tenure committee. So everything he says about con law, I'm sort of thinking as I was a sort of baby law prof teaching con law under the tutelage of Congressman Jamie. So one of the things I was thinking about this morning is how grateful I was to begin the day with the role of history, because the ghost of history is all through our discussion of education and the tying to citizenship in the United States. And I think it is an important moment as we are imagining a utopian future, as we've talked about, to think about how we use that through line of history to look at how integral education has always been deemed to be to the role of citizenship in the United States. And so we know that it was an integral part of slave codes to ensure literacy for enslaved persons. We know that we have, abolitionists from Frederick Douglass to Harriet Tubman talking about what it means to have a right to education. So we have this rich history beginning even before the founding of that second contract about what the role of education meant. And I'm always reminded about that quote of, once you learn to read, you will be forever free. So this is really a through line in our history, this importance of education that begins all the way from fighting against those slave codes, what it meant for Frederick Douglass when he said, how can you expect to be a part of this country if you can't even read the Constitution to understand what it says? Then you fast forward to the passage of this second social contract, this new founding of America with the 14th Amendment that is so integral to how we think about how we move forward. And it is the document that changed our understanding of national citizenship and an idea of citizenship equality. And again, all through those discussions of what Sherilyn calls our second founders, Sumner and Thaddeus Stevens and Bingham, they're all talking about why we need this amendment to educate Black people in America, to educate those who are formerly enslaved as well as free, and that this was the piece that was holding everything together. This lack of education was essentially integral to enslavement, and providing a blueprint for education would be integral to bringing in free and formerly enslaved people as full members and full citizens of our society. Mm-hmm. And so that's very much, if you look back to that Reconstruction Congress, it's very much a part and parcel of what they're talking about. It's very much a part and parcel of, the Civil Rights Act of 1866 and 1870. It's part of the Freedmen's Bureau Act. That funding, look at where we are. We're here at Howard University. Howard University comes out of that, saying out of slavery, out of the path to freedom was to actually fully fund the education of Black people in the United States. And that's where we get HBCUs. It's where we get not only the Freedmen Bureaus Act, but also the Freedmen Savings and Trust, where the money was earmarked for education. And so I raise that to say there's a through line from enslavement to the Reconstruction period to then what happened, as we know, with Plessy versus Ferguson and several more decades of racial apartheid in the United States, where we didn't really have the full meaning of the 14th Amendment realized. And then we get to Brown. And then we get 10 years later to the Civil Rights Act that also kind of gives some meat to that. But as Sherilyn said, we have a series of Supreme Court opinions that really do underscore the importance of education to the functioning of our society. That it is a really, when you think about educational institutions, that they are really foundational democratic institutions in our country, in our constitutional democracy. And when you look to the meat and potatoes of Section 1, there are various places that we see this and various battles that have been fought in the Supreme Court about how to make that real. Even before Brown and even before we're talking about issues of racial literacy, we certainly have opinions from, we have it as part of the Northwest Ordinance and things like that long before the second founding, but we have opinions like Pierce versus Society of Sisters, Wisconsin versus Yoder, Meyer versus Nebraska, that are all about the importance of education. When we get to litigating where the 14th Amendment really protects this right, we have had some issues, and so that's where the LDF litigation comes in. I'm sure Deuel is going to talk to us about that. But, what is famous is we do have Brown saying, education is the very foundation of good citizenship. This is the building block. And then we have in the early 70s San Antonio versus Rodriguez that says there's no fundamental right to education that is recognized under the Due Process Clause of the 14th Amendment. I would say, and other scholars have said, you could really see this right embedded all through Section 1. It is a part of the Citizenship Clause because it is foundational to citizenship. It is a part of the Due Process Clause where we recognize what are fundamental rights and what is more fundamental than this right to education, which is the key to freedom. And the systemic denial of a right to literacy is a violation of the Equal Protection Clause. So I'd argue you've got three parts of Section 1 that really hone in on this. We know Rodriguez did not hold that there was a fundamental right, but it left open the idea that an absolute deprivation could be a denial of a fundamental right. And that's where we get to the 1982 case, Plyler versus Doe, which said that an absolute denial of a free public education to undocumented immigrant children is a violation of the Constitution. So I think if you put all of these pieces together and you get to where we are in 2025, we're at a point where this is not a partisan issue. We're at a point where when we see a violation or a stripping away of educational opportunity, this is hitting everybody in America. And you have folks even in Deuel's favorite state of Alabama that are wondering, well, we might have voted for a particular president, but not for him to take money away from our schools, not to sort of shut the schoolhouse doors in certain very key ways, not to dismantle the Department of Education. So I think it's time for us to look at a revisiting of what it means to actually advocate for the true meaning of a right to education that is fundamental to American citizenship.
Thank you so much. Thank you, Leah.
That's awesome.
Serena, you were part of a team of constitutional lawyers that wrote a brilliant amicus brief in the Dobbs case, really bringing equal protection into the argument for reproductive rights and reproductive protections. It's interesting that Justice Alito actually, I did not expect him to acknowledge the brief, and if he did acknowledge it, I would have assumed it would happen in a footnote, as often happens with troublesome amicus briefs, right? Amicus have argued that, but that is, in opposite to this case, or something like that. I did not expect it in text, and I did not expect that he would feel he had to address it before he went into his argument for why abortion is not a fundamental right. What that tells me is that it was a bother. It was not something that was glossed over. It hit a nerve, probably among other justices on the court, and that made him feel like he had to respond to it. So I will just start by asking whether that was your assessment, but more importantly, asking you to really flush out for folks here what you were arguing in that brief and what you see for this going forward.
Thank you so much, and I just want to echo the thanks. I can't think of a better place to be and better company to be in at this particular historical moment than here with all of you at Howard. So I'll say a little bit about what this brief, which was really built on years of work by my co-authors, who were really the primary authors, Reva Siegel and Melissa Murray. So first, the brief argued that the Supreme Court's 1974 decision in Geduldig versus Aiello, which was cited by Justice Alito in Dobbs as still being good law, Geduldig held that pregnancy discrimination somehow is not always discrimination based on sex under the Equal Protection Clause. And we argued that that decision had been superseded by really a half century of jurisprudence and congressional lawmaking that had subjected classifications based on pregnancy to heightened scrutiny under the 14th Amendment, under the Equal Protection Clause, and recognized restrictions on abortion and reproductive autonomy more generally as being based on sex-based stereotypes. Cases like United States versus Virginia and Nevada versus Hibbs that had been decided in the intervening years. And then second, the brief talked about the origins of abortion restrictions in a physicians' movement in the 19th century led by Dr. Horatio Storer, which was animated not just by a desire to protect fetal life, but also by nativist fears that elite white Protestant native-born women's reproduction would be outpaced by that of Catholic immigrants and of people of color. And we tried to show how physicians and lawmakers who restricted abortion also did so based on what we would now call sex stereotypes, right? That women were destined for motherhood and that the availability of abortion would allow women to shirk their divinely ordained roles and would lead to their physical and mental ruin. There's lots of amazing commentary about that in the pages of 19th century medical journals and elsewhere. And the brief, moreover, drew parallels between those stereotypes and those that underpin today's abortion restrictions, which claim to protect, or at least they did, I'm not sure we're even claiming this anymore, but claim to protect maternal health and welfare as well as fetal life, and life more generally. And then I think in sort of the heart of the brief was about how the claim about protecting maternal health and life, fetal life and life beyond birth, is of course belied by the policies of states like Mississippi and other states that ban abortion. So we said if lawmakers were truly motivated by the protection of health and life, before they banned abortion, they would first maybe expand Medicaid, provide access to comprehensive sex education and contraception, child care and transportation. They would protect pregnant workers from discrimination, perhaps, and ensure basic subsistence and support for families. They might address the maternal and infant health crisis facing particularly Black and Native communities where pregnancy and childbirth kills 3 times as many people as white women. Well, I don't have to tell anyone in this room that Mississippi and other states that ban abortion have not done any of those things. And then the final part of the brief, which I also think was very important and drew upon Professor Murray's work and others' work who have refuted these arguments put forward by some judges and others that abortion is a form of eugenics targeted in particular at Black Americans. And instead, the brief placed abortion restrictions within a long history of reproductive control, including forced sterilization and other punitive policies designed to reduce childbearing among certain women and increase the reproduction of others. And as Judge Reeves did in his opinion in the Dobbs case, the brief noted in particular Mississippi's shameful history of racial and sexual subjugation, which animated Mrs. Fannie Lou Hamer's crusade for voting rights and against sterilization abuse. So I still believe these arguments are compelling and correct. And as you mentioned, I think maybe Justice Alito might have been compelled by them too, at least
Stone.
needed to brush them aside. But I also think that if we were building equal protection from the ground up, we would probably begin from a different starting point than our brief did. So the Dobbs majority, as you may know, used this very narrow and selective and distorted version of history and tradition to freeze our constitutional rights at a time when women and people of color were excluded from the polity. But the court never so much as mentioned the history and animating purposes of the Reconstruction Amendments themselves. And as legal scholars such as Peggy Cooper Davis, Dorothy Roberts, Michelle Goodwin, Lisa Crooms Robinson, and others have argued for decades, the 13th and 14th Amendments were enacted to undo a legacy of enslavement that centrally included brutal sexual violence and reproductive control. As Professor Cooper Davis wrote almost 3 decades ago, if one follows the principle that freedom is slavery's opposite, one must conclude that the anti-slavery movement understood freedom to entail protection against totalitarian control over people's bodies and reproductive lives. And even if we just looked at what the framers of the Reconstruction Amendment said and did and understood about how central reproductive control was to enslavement, we would have a very different picture of what equal protection requires. But if we follow Professor Cooper Davis and examine what she calls neglected stories, and not just the views of 19th century lawmakers, but also the ideas and experiences of enslaved and freed people, we can recapture what she calls an anti-slavery history and tradition. And we could see reproductive freedom and autonomy as central to the liberation that the Reconstruction Amendments promise, and recognize Black women, as Professor Jones exhorted us earlier, past, present, and future, as the leading authors and subjects of our constitutional meaning. So this might lead us to much more expansive and capacious views of what equal protection requires that would encompass a broader vision of reproductive justice defined by Black feminists in Sister Song as the right to bodily autonomy, to have children or not to have children, and importantly, to raise the children we have in safe and sustainable communities. It might encompass a right to subsistence, a right to freedom from violence of all kinds. It might power a right against family separation. That was also a hallmark of enslavement. It might animate what Dorothy Roberts has called abolition constitutionalism. And it would really grapple with the second founding as one that superseded the first founding and whose promise really has yet to be realized. And as Reverend Lamar said earlier, it would tell the stories of all of our ancestors and how they matter to the Constitution today.
Thank you. That was excellent. Yes, I see. Okay. I hope you will join me. So again, as I suggested, this is designed to help you get a taste of the kinds of conversations, thinking, strategy that we want to be doing in the center, right? This was not to come up with the draft legislation, right? But this was the idea of showing how we can begin to ourselves grapple with finding the world that we want, right, in the existing doctrines that were created for the purposes of finding a new nation. And I can't imagine any better crew of people to come together and really just provoke this exciting conversation and this exciting way of thinking. We want to support scholarship in this area, so we want to make sure people are writing about this. And we want to begin to do that work that we talked about in the first panel, the work that happens years and decades, sometimes 10 years, sometimes 14 years, before we realize what we really want. But we won't get what we really want if we don't start doing it now. So I want to thank Jamie Raskin, Leah Epperson, Donald Sherman, Serena Mayeri, Deuel Ross for being with us today. Thank you so much.